Well, welcome to online contracting. Let me make sure that I have enough volume. There we are. So I'm Professor Warner. This is online contracting. This is the first of the videos. Let me get our slides started. If Zoom will cooperate with me. There we go. So preliminaries before we start. So as I said, this is the online contracting course. You're looking at our first topic, which is allocation, risk allocation terms and normal course terms. Before we start on that, let me note that you can email me at either of these email addresses. They're linked, so emailing one will get you to the other. You'll probably get a reply from me from the Gmail address, since that is the one that I usually have open. Anything else? Any questions about the exam, about the School of American Law, whatever, just email me. I will respond as quickly as I can. With that, let's get started. So, as I said, our topic is online contracting, and it's what we're familiar with, right? Here's an example from Amazon.com. If what you're looking at is the very bottom of their homepage, if you scroll down and down and down and down, you will eventually get to this, and you'll see what I put a red circle around: conditions of use and privacy notice. Those are the online contracts. And we want to understand a number of issues that arise with those that are making contract law change a bit, or at least adapt in response to this way of contracting. And that's something new for contract law, right? I mean, the contract law changes very, very slowly, but it happens in this area to be in a situation of rapid change. Just unusual, interesting, and instructive, and also quite important for anyone in a business practice, prosecution, whatever, right? Because everybody has issues about online contracting. So there's an example. We gave Amazon as the example. There's an example of what you find behind the terms of use agreement. We will talk at some length about this, because the claims you're looking at deal with offer and acceptance in contracts. But for now, we just want to have an example of what we're talking about. So what we're all familiar with, online contracting, we all go to home pages. They typically have this kind of presentation. Now, if you're like me, you don't read these things. I read them because I teach this course and do research about this, but normal people don't read these things, right? They just sit there behind the hyperlink unread. And that's something we will have to deal with. But there's an example, and there's a fuller example of the terms, right? We'll come back to this, but this is out of about 3/4 the way through Amazon's terms of use agreement comes this disclaimer of all sorts of liabilities. By the way, this happens to be in capital letters because US law requires that a waiver of liability like this be what the law calls conspicuous. And the number of cases have held that putting it in capital letters makes it conspicuous, right? So that's what we're ultimately going to be concerned with. We're going to be concerned with online contracting. But for half of this course, a third to a half, I would think, we'll be concerned with offline contracting, right? Not online contracting, but what we're familiar with from other experiences, offline contracting, right? So why? Because the way to understand what's going on in online contracting, what makes it unique, what poses its problems, and how to solve them, the way to understand that is to understand offline contracting. We're also familiar with offline contracting is, so to speak, the contract in the box, right? You all know this. You go to buy some consumer product. This, what you're looking at, is a piece of software. They go to buy some consumer contract in a store, not online. You get the box. take the box home, you open the box. In the box is what consumers call the warranty. This piece of paper, what consumers call the warranty. That is the contract between you and the manufacturer of the product. And we're quite from, this has been going on for at least 100 years, right? And here are its characteristics. These are the characteristics of offline contracting. And they, of course, turn out to be characteristics of online contracting as well, because our online contracting develops just from our practice of offline contracting. So importantly, think about the paper in the box, right? Think about the warranty, the paper in the box. It's the same for everybody. When I buy my software or my computer or my smartphone or whatever, I don't get a different contract from you. I get the same one. Everybody gets the same one. One size fits all, right? Same for everyone. No negotiation. Nobody strictly speaking, if you're buying an expensive enough consumer product, there may be a tiny bit of negotiation about warranties and so on, but usually no, right? For our purposes, we'll just think no negotiation. That is so close, 99% of the time, we can ignore the tiny little bit of negotiation that may go on in some consumer contracting. So no negotiation. Why? Take it or leave it, as it's often said. Here's the deal, right? Here's the deal. Here's the deal, right? In the box after you bought it, there's the deal. Take it or leave it. No other deals, no negotiation. And very importantly, this will turn out to be extremely important for us in online contracting too. Business as we know it would be virtually impossible without standard form contracting, without the take it or leave it, no negotiation contract. How do you contract with millions of people? You don't negotiate each one separately. You just have one form, one deal for everybody. And if you took that away, business consumer transactions as we know them would disappear. Right? So it'd be virtually impossible without, right? So that is a reason to save it. This theme will come back a couple of 2, 3, 4 times, right? So I noted here, it's a feature that's been around since we use standard form contracting for consumer products. And another important feature, let's take this one. Let's clean up our slides a little bit. People do not read them. I don't read them unless I have to. My wife is a real estate agent. Sometimes she makes me read real estate contracts. Oh, excruciatingly boring, especially after you read several, because they tend to be all the same. But I don't read consumer contracts, not unless I'm doing research. I assume you're the same, right? Nobody reads them. And we're talking about ourselves as pretty much a group of lawyers, but even if non-lawyers read them, they wouldn't understand them if they did read them, because they have to understand stuff like what you're looking at now. It takes a reasonable amount of contract law, and in this case, US contract law, to understand what's going on here. And most people don't have that. And if you look at the online contracts, they often contain a great deal of information about data processing and about allocations of risk from online activities like viruses and hacking and other forms of unauthorized access. Now, I understand this stuff, but I specialize in that area and I spent a number of years studying it. And so I can, I think I have an idea of what's going on, but it took me years to get, and I don't have as deep an understanding as experts security experts, computer science experts by any means. So even the trained lawyer will understand the legal terms, but not struggle with the other technical terms. And that's not just a feature of online contracting. That's actually routine in offline contracting as well. My favorite example is buying a water heater. Water heaters come basically in three types. The types with cheap insides and a very small, a very limited warranty, medium expensive insides and a medium warranty, and expensive insides and a long warranty. So if you're reading your water heater contract, to evaluate whether the warranty you're getting in the contract fits with the product you're buying, you need to know something about water heaters. I only learned about water heaters for the purpose of this example. Otherwise, I wouldn't know any of this, right? And the same problem comes up in intellectual property licenses and in construction contracts, right? To write them, you need to know a lot about the field, the intellectual property issues, the construction issues that you're working with. And to write them, you need to understand the field, and to read them and evaluate them, you do too. So people don't read them. Non-lawyers certainly struggle, and lawyers will struggle unless they have a lot of relevant technical knowledge. Importantly, we've been doing this for 100 years. The remarkable fact, right? What I just described doesn't sound, oh my goodness, people don't read them and they wouldn't understand them if they did. Why would we do such a thing? We've been doing it for 100 years plus, right? This standard form contracting, one size fits all, no negotiation, everybody gets the same deal. That appears in the 18th century with the rise of standardized goods. As people in the economy started to sell standardized goods, they started to contract with more and more and more customers. What was the solution to contracting with large numbers of buyers, right? Many of whom you may not even know. Back in the 18th century, maybe hundreds or thousands, now literally millions, right? Standard form contract is the solution. Well, it's the same for everybody, right? So we don't have to do it one at a time for a million times. Same for everybody. That's the solution. And in those contracts, that not in the offline contracts that we've had 100 years of experience with, they have a characteristic that you do see in the online contracts as well, but you see more in the online contracts. And that's where we're starting, right? Our first step into online contracting is the comparison with offline and online, and in light of the terms that they contain. So the offline ones contain a lot of risk allocation terms. The risk allocation terms were central. That's mostly what's in there. Of course, you got to see who are the parties, who's going to do what for whom, and how much are they going to pay, right? But once you get that done, right, all that housekeeping done, it's mostly about if things go wrong, who bears the risk, who pays, and that's what the risk allocation terms are, as you can see on the slide. Here's one from Amazon's contract. This is part of the capital letters thing we looked at earlier, right? Amazon will not be liable for any damage of any kind arising from the use of any Amazon service or from any information, content, materials, products, including software or other services included on or otherwise made available to you through Amazon service. In other words, they're not liable for damages. What does it do? Allocates the risk of using Amazon to the user, not to Amazon. Risk allocation. And so, as I said, in offline contracts, risk allocation terms take up most of the contract. That's what they're largely about, right? Who's going to bear the risk of things, the risk when things don't go as planned. Now compare what you might call what I call normal course terms. So not risk allocation, but normal course terms. They say what the parties' permissions, rights, and obligations are when things do go as planned. Right? When things do go as planned. Yeah, you see some of these in offline contracting. In your apartment lease, the typical to have a normal course term that says the landlord may with notice enter, right? entered the apartment. Employment contracts specify obligations from which rights and things that exist in the normal course of the employment contract. Insurance contracts also, and so on. But in general, normal course terms are not nearly as common as risk allocation terms. And you certainly see that, right, in our Amazon, well, you see it, Amazon is an online contract that has both, as it turns out, but you certainly see mostly risk allocation terms in the typical purchase of a consumer product, because what we're concerned about in the contract is whose responsibility is it when the thing in the box doesn't work right. So let's take a look at another online contract. This is the New York Times Online risk allocation terms. This is from the table of contents that they have for the terms of use agreement. And so you can see these 4 general headings pretty much cover their risk allocation terms. Now, if you add the normal course terms, which I put in red, you can see that there are a lot of them, and they make up a lot of the contract. So this is a difference, right? Offline, mostly risk allocation terms, not many normal course terms, so except in some special cases like employment, apartment leases, and so on. But you look online, and all of a sudden, you have a whole bunch of normal course terms that you don't find anything like this in offline contracts. So our first question, why this difference? What's going on? Yeah, and so we're going to look at offline contracting, and there can compare modern online contracting. And down here, of course, what we'll discover is that here in the second modern online contracting, we're concerned about information processing, data collection, data analysis, distribution, use, and we have a ton of normal course terms to cover that. But we could say that now, but we'll understand it so much better when we develop our picture of offline contracting and then compare it to modern online contracting. So let's start with the traditional problem of offline contracting. And let's just make that clear in the side. Right, this is the traditional problem that arises for offline contracting, and we'll see. As we'll see later, just so we're not confused about it, also arises online. And while we're at it, let's correct a typo. There we go. So our first problem is that we'll start with traditional offline contracting. Well, what terms should you be able to put in a contract that consumers will not read or understand? Think about it. Go back to our let's find our characterization. Yeah, that got away from me. There we go. I don't know why I just kept jumping by, right? This is the remarkable fact. We let contracting go on. We have for 100 years, right? Where we know people aren't going to read the contracts and even wouldn't understand them if they did. So what terms do we let the business put in those contracts? Because if we let them put in anything, I guarantee you some business will take advantage of that to put in incredibly unfavorable terms for their customers. So how do we restrict these? Right? That's our first puzzle. And we have these doctrines. Make it 1, 2, 3, 4, 5, 6. These 6 doctrines taken together all give us the answer for offline contracting. And then we're going to take this answer and compare it to online contracting and see how well it works, what changes arise, what problems arise, and we'll see a lot, right? And so we'll get both a picture of traditional offline contracting for consumers and a very good picture of modern online contracting, right? So that's our goal. Our goal as we get started is offline contracting, background to understanding online contracting. I emphasize that because we'll spend a fair amount of time on traditional offline contracting to build the basis for our understanding of offline contracting. So as we go on, I don't want you to forget that understanding online contracting is our goal. We're just going to do a fair amount of work setting the background, the foundation to understand our online contracting. So with that, if I can find me, let me stop. There we go. Let me stop the share. So that's our introduction. As I say, you've got issues, questions, problems, email me. My rule about email is I try to answer as quickly as I can, first come, first serve. It's always a busy time for me. So I will answer. If I don't answer, email me again. We do this kind of teaching does best if we interact. We can interact by email, right? So we get a little more personal interaction than these videos. So I think if we work at it, right, you ask me questions, we'll have a good course that leads us to understand on consumer contracting better. And by the way, I mean, your experience has been in the civil law outside the United States, obviously, and I'm very interested in how your experience of contracting compares to the US experience. So if you want to add anything to educate me in that regard, please do. Okay, that does it for this video. I will see you in the next one. Take care.